that except for Section 6 of the Act, which pertains to having a counsel of the choice in review, the rest of the Act, the Parliament did not have the necessary legislative competence. And my Lord, why I am making the exception with regard to Section 6, the answer lies in Article 188, read with Article 199. So, with your Lordship's permission, I'll read Article 188.
Mic करीब करने दो.
जी फरमाइए.
Article 188, review of judgments and orders by the Supreme Court. The Supreme Court shall have power, subject to the provisions of any act of Majlis-e-Shura, Parliament, and of any rules made by the Supreme Court to review any judgment and order. Act of Majlis-e-Shura or Parliament, not law. While coming to Article 191, subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the court. Now, my Lord, the framers of the constitutions were clear in their mind that they wanted to confer the legislative power upon the Parliament to have a law for the review, but not for the practice and procedure, my Lord. And the wisdom might be, the wisdom might be that in review, a right of a party is involved, while practice and procedure is the internal matter of the apex court.
But counsel, review ke upar bhi, there is already a provision in the Practice and Procedure Act, and review ka jo Section 6 aapne padha hai, that relates to a question of procedure. So where the procedure is already provided, and it has been argued with some force that the power to make procedure and rules and procedures vests exclusively with the Supreme Court to the exclusion of any other organ. Then once that procedure has been provided, another procedure cannot be provided by the Parliament to override that procedure. That is the argument made. What is your answer to that?
My Lord, I totally bow before that observation, but my submission is that only to the extent of legislative competence, the Parliament has the domain. The Parliament, in principle, can provide for a law regulating the review, but not the practice and procedure. Otherwise, the term Parliament or Majlis-e-Shura should have been used in 191, which is not the case, my Lord. This is my first submission. And Honorable Justice Jamal Khan Mandukhail had the
आप चलिए आप अपना आगे केस आर्ग्यू करें.
my Lord, question.
Other point.
Other point is that, my Lord, this conferring of domain or competence, legislative competence upon the Majlis-e-Shura without having a specific item number in the federal legislative list or the substantial part of the Constitution, it means we are giving the Parliament a power which it did not have, and that has broader implications for the federation and the federal structure, my Lord. Lordships would appreciate that father of the nation wanted a federal state, and he wanted autonomy of the federating units. We are, my lords, interwoven in a very delicate and complex relationship. And what guarantees the autonomy of the federating units is the fact that there is a federal legislative list, there is no provincial legislative list, and the concurrent legislative list is gone. So anything which is neither in the federal legislative list nor in the substantive part of the Constitution is a provincial matter, my lord. So, if this honorable court gives the parliament the power to enact on a subject which may not be there in the federal legislative list or the substantive part of the constitution at the garb of item number 57 and 58, or at the garb of incidental and ancillary powers, it means that the parliament may encroach upon the provincial subjects.
पहले नेक्स्ट पॉइंट, ये तो आर्ग्यूमेंट अजीब सा है, तो आपका कहना है कि 4 सूबे अपने अपने कानून बना सकते हैं?
No, ये नहीं है मेरा.
तो ये आप यही कह रहे हैं?
No, my lord. Residuary matters. There is no provincial legislative list.
हमें पता है ना, इस कानून की बात करें ना.
My lord, it has implications. It has implications, and these are not remote implications. These are immediate implications.
अगला पॉइंट बताएं. हाँ.
So the submission is, the prime submission pertains to the legislative competence or the legislative incompetence of the federal legislature, my lord. My second submission is that, and it was pointed out by Honorable Justice Musarati Lali in the form of a question.
Please आपका direct argue करिए.
My lord, answers भी तो brief मैं time नहीं लूँगा. That apparently, by virtue of the act in question, the office of the Chief Justice has been done away with. It has been abolished for all practical purposes, my lords. And lordships would appreciate that as per definition given by Article 176.
Before you say this, first say which provisions of the constitutions create the office of the Chief Justice, which has been abolished.
My lord, 176 defines the Supreme Court, which says that the Supreme Court shall comprise of the Chief Justice and judges, as many judges as determined by the Parliament or Presidential Act. So the institution stands on 2 limbs, office of the Chief Justice and judges, my lord.
आपकी अगर ये बात मान ली जाए तो आप कहते हैं कि चीफ जस्टिस और जजेस अलग-अलग नहीं है, एक ही है.
My lord,
और अगर एक ही है तो फिर क्या चीफ जस्टिस अकेले रोस्टर बना सकता है?
My lord, रोस्टर बनाने से पहले मैं एक अर्ज कर लूँ, my lord. We hear that the Chief Justice is senior among equals. While sitting in the judicial capacity,
let's not go over point आप बताएं ना.
Point पे आ रहा हूँ, my lord. While sitting in judicial capacity, he is equal among the equals.
आगे बढ़िए. What
makes him senior among equals is administration. Now, what has been done through this?
There are certain powers specifically bestowed on the Chief Justice in the Constitution.
May I refer to them, my lord?
Yes, there's some powers have been specifically bestowed on the Chief Justice.
Thank you, my lord. I'm referring to them. Some of the powers, my lord. Article 183(2).
Whether the specific mention is of Chief Justice.
Seat of the Supreme Court, Clause 2. The Supreme Court may from time to time sit in such other places as the Chief Justice of Pakistan, with the approval of the President, may appoint.
This is destructive of your argument. Here the Chief Justice has been given this power, not the Supreme Court.
Yes, my lord. Yes, my lord. Because it is at the administrative powers. It is the indication that the Chief Justice is the master of the rules. He is a pater familias. This is the first indication.
ये लफ्ज इस्तेमाल हो रहे हैं, मगर ये आइन में नहीं है, केस लॉ में है.
आइन में यह है कि Chief Justice on his own, without any consultation, without any recommendation of the committee, shall appoint the place of sitting.
Correct.
Yes,
because the Constitution says so.
So administratively, the Chief Justice has at least some say. While the impugned act, मैं दूसरे provision पे आता हूँ.
Benches के हवाले से वकील साहब, with the approval of President.
Yes.
सर्किट बनते हैं ना.
Yes.
ये उसके हवाले से. और ये constitutional provision है, इसके लिए rule की जरूरत नहीं.
Yes, my lord. No rule is required.
इसका notification होता है.
Yes, my lord. Yes, my lord. But under the Constitution.
इस सिलसिले में नहीं है जो आप बात कर रहे हैं.
तो बेंच बनाने का पावर है, बेंच का पावर विद द अप्रूवल ऑफ प्रेसिडेंट होगा, और उसके लिए रूल तो वही अप्लाई होंगे जो ऑलरेडी पहले से रूल इन फोर्स है. ठीक है.
Exactly, my lord. Exactly. But now, Article 10, Clause 1, Roman 1, Federal Review Board. Article 10, 1, 10,
10.1.
1, Roman 1, after the explanation in the bottom.
जी हाँ, चीफ जस्टिस का जिक्र है.
In the case of a person, is that before your lordship? In the case of a person detained under a federal law, a board appointed by the Chief Justice Pakistan and consisting of a chairman and 2 other persons, each of whom is or has been a judge of the Supreme Court or a High Court. Now, for all practical purposes, this is a bench to be constituted by the Chief Justice of Pakistan, my lord.
This is not bench of the Supreme Court. This is not a bench of the Supreme Court.
Not strict to senso, but a forum is appointed by the Chief Justice.
We are talking about the bench constitution, composition of the benches of the Supreme Court.
मैं एक अर्ज कर रहा हूँ, जो पॉइंट मैं बता रहा हूँ वो ये है कि under the constitution, in the administrative matters, the Chief Justice is on the driving seat. Now I'm referring to Article 146(3), 152, 159,
146,
Clause 3. This is only for reference. I'm not reading, my lord. 146(3),
जी
152 and 159, Clause 4.
152,
152 and 159, Clause 4. Under these provisions,
152 or 150,
9, 4.
class 4. जी.
Under these provisions of the Constitution, the Chief Justice is empowered to appoint an arbitrator in certain fiscal matters, in certain disputes, my lord. Now, under the original Constitution, prior to the 22nd Amendment, the Chief Justice was empowered to appoint a caretaker, Chief Election Commissioner, out of the judges of the Supreme Court. Under the original Constitution, prior to the 17th and 18th Amendment, the Chief Justice alone acted as a consultee for appointments in the judicial.
What is the point you're making?
My point is, my lord, that when we say that the Chief Justice is senior among equals, what distinguishes the Chief Justice from the judges? Administration. Otherwise, the Chief Justice would be equal among equals.
Okay, but you are saying that because these specific provisions of the Constitution specifically mention Chief Justice, so by analogy, he has other powers as well. That's what I've understood from your argument.
By analogy, he is the senior among equals.
Okay.
And you see, where there is a power under 191 to frame rules, the rules are for the purposes, administrative purposes. And in addition to the rules, there are constitutional or there are conventions of the court which have invariably been followed since since the 1956 Constitution, and before that the Government of India Act. So those conventions have also acquired the place of rules, or for that matter, the procedure of the court.
Yes, my lord. Article 268(7) is very much clear to that extent, that anything having the force of law has been deemed as law,
Yes,
my lord.
268(7).
268(7), my lord. Now, what this law has done, the law does not say that the Chief Justice, in consultation with the 2 senior judges, shall constitute a bench. No. Had it been so, it would be least objectionable. What has been done, my lord, that any 2 of the 3 may constitute a bench. So the office of the Chief Justice has been converted into that of a senior judge, or the positions of the senior 2 judges have been converted into quasi-chief justices. This is my submission, my lord. There is no consultation. While concluding the arguments on the previous hearing, your lordship mentioned to the preamble, Article 2, Article 2A, 227, and I'm grateful that your lordship referred to the Grun norm. No consultation is there in this law, my lord. No consultation. And one potential deadlock which I see, not today, say 50 years from now, my lord, the two judges on one side, the Chief Justice on the other side, 50 years from now, the two decide.
Why 50 years from now? Why
My
not
lord,
tomorrow?
not regarding the
आप
incumbent.
मफरूज हैं, चलें आगे बढ़े ना आगे
मैं एक potential
आप इतना लंबा तमहीद बांध रहे हैं
मैं 5 मिनट में
चलिए कह दीजिए
if the two judges are
हाँ ठीक है तो he
on
be in
the
a
one side,
minority, big deal.
and the two decide
So what?
that my honorable the Chief Justice, we have established, we have created a roster, and according to that, for the next month, you will do the chamber work.
ठीक
You will not sit on a bench.
ठीक है
So the office of the Chief Justice has been paralyzed, my lord.
Chief Justice can do so himself.
I'm not saying, my lord. I'm
So
not saying.
it implies that Chief Justice can do so, it's okay.
I'm not saying
But if
this.
two senior judges do so, it's wrong.
My lord, there cannot be
या
any.
तो कहें कि कर ही नहीं सकते हैं तो बात खत्म हो
There
गई.
cannot be any Supreme Court without the Chief Justice. This is my point.
We know that because the Constitution
The
says
Constitution says.
Yes.
And that would tantamount to sending the Chief Justice on forced leave. Such like enactment made by a dictator has already been nullified.
तो इसका मतलब ये हुआ कि अगर चीफ जस्टिस के पास पावर हो और वो कहते हैं कि ये दो जजेस जो है ये अगले 1 महीने तक चैम्बर वर्क करेंगे फिर क्या होगा?
अगर कोई डिफिशिएंसी है रूल्स में,
अगर में चले तो अगर ये भी हो सकता है
अगर डिफिशिएंसी, I'm not saying, I'm not going to the wisdom of this law. I'm referring to the potential dead end we may go into.
ठीक ठीक
लर्नड काउंसिल आपने
पहले आगे
अभी
बढ़े।
तक लर्नड काउंसिल अभी तक आप फ्यूचर का बता रहे हैं एज द लॉ स्टैंड्स टुडे हाउ आर यू इनकन्वीनियंस्ड आपका कौन सा पर्सनल राइट जो है इन्फ्रिंज हुआ है एंड व्हाट फंडामेंटल राइट आर यू ट्राइंग टू इन्फोर्स बिफोर अस
That question goes to the maintainability of the petition, my lord. And except for 3, all fundamental rights are subject to law, subject to reasonable restriction imposed by law.
आपसे सिंपल ये
उसी पे आ रहा हूँ, my lord.
either say yes or no are you inconvenienced by this law
Yes.
Has any fundamental right of yours, has it been infringed?
Yes,
And
my
please
lord.
kindly tell us what fundamental right are you trying to enforce?
Yes, my lord. I'm referring to that.
You don't want,
I have the
you
prime
don't want
right.
access to justice to be.
No.
कुछ और इन्फ्रिंजमेंट बता रहे हैं बताइए.
Yes, my lord. All fundamental rights except for the dignity of man and forced labor and slavery, all have been subjected to law. Now the law means
Dignity of
validly
the Chief
passed
Justice.
law, validly passed law coming from a competent legislature, that I may not be subjected to a law for which the respective legislature is not competent. This is all fundamental rights are involved, my lord. And the mother of fundamental rights, Article 4.
ये इन्फ्रिंजमेंट का बताइए ना कौन सा फंडामेंटल राइट इन्फ्रिंज हुआ.
My lord, if the law is maintained without the necessary legislative competence, it means I'm subjected to a law for which the parliament was not competent. So it is going to affect every fundamental right.
ठीक और कोई point?
Now, furthermore, under the constitution, all judges are equal, my lord.
जब कह चुके हैं
अपने आगे बढ़े ना.
मैं आगे बढ़ता हूँ.
अब हमें कोई लेक्चर ना दीजिए जो लॉ स्कूल में देना चाहिए प्लीज.
ठीक है, मैं अपील पे बहुत कुछ कहा जा चुका. मैं सिर्फ एक पोटेंशियल मिसयूज, एक पोटेंशियल. My lord, under the impugned act, the committee of 3 judges may themselves sit in a bench constituted under Article 184(3). Now the judgment comes and there is an appeal stage. Now the same committee will decide as to who should hear the appeal against our judgment.
So what's wrong with that?
My lord, it amounts to appealing unto Caesar against Caesar. There is a potential conflict of interest. If I would have been a judge, I would have an interest that my judgment is preserved.
When you become a judge, we can look into it.
No.
चले.
So this,
बस
and my lord, मैं दो points करता हूँ. As per section 77 of the Act, which says that every case having urgency or where there is a prayer for interim relief shall be fixed within 14 days. Hardly there would be a case in which there is no prayer for interim relief. So
there will be what?
In which there is no prayer for interim relief. Almost every case has a
I think
prayer.
you're mixing up the concept of interim relief with urgency.
The word interim relief has also been used.
ठीक है, okay. So
May I read
we
one
can apply our brain, which we do occasionally.
Okay.
And we can determine what is urgent and what is not urgent. So what's the big deal about it?
What is objectionable? What is objectionable? That the affairs of the apex court have been micromanaged. Even the civil court ordinance, even the CPC doesn't micromanage the affairs of a civil judge. It is in this way contemptuous. It is insulting. Throughout the world, we have phrases like case management, court management. These are the inherent powers. These are always left to the court, let alone the apex court.
Actually, I'll tell you what we did. I've constituted a committee for case management. So I have given my powers already to a case management committee. So you are saying that act of mine is unconstitutional?
No, my
Because
lord.
only I can do it myself, or the full court can do it.
No, my lord. It is for this honorable court to do case management. Whoever is delegated that function,
ठीक.
it is. But the law cannot micromanage those affairs.
Okay. Chaliye, next point.
Now,
Your point is that by enacting this law, a power of micromanagement has been conferred on the parliament, which would open the door for it to micromanage not only these things, but subsequently any other thing that it needs to interfere with.
yes, my
And
lord.
that would affect the separation of powers and the independence of the judiciary.
Yes, my lord. And in legal philosophy, it is called the slippery slope theory.
Sorry?
Slippery slope.
Slippery
theory.
slope.
Yes, my lords. Once you are on a slippery
चलिए
slope.
आगे बढ़ें.
Now, concluding my
Learned Counsel, there was a judgment from the Peshawar High Court regarding the internment centers. For the last 4 years, that petition is pending before this court. And the Chief Justice felt, many Chief Justices, that that was not an important case enough to be fixed before the court. So you justify that? You
My lord,
justify the exercise of such power?
I'm
And
affected.
that the parliament is bereft of jurisdiction not to come to the rescue and ensure access to justice by merely regulating a discretion of the Chief Justice?
My lord,
Do you defend that, justify that?
I am the effectee of that case. I'm a petitioner. I'm
Are
a
you
counsel in that
justifying-
case, my lord.
Are you justifying it?
That again goes to the wisdom of this law. Wisdom is always with
If you are an effectee of that case and I tell you I will never fix that case, what will you do?
that would, if
No, to answer the question.
वही answer कर रहा हूँ.
If नहीं, I'm telling you, I'm saying it, I'll give you the exact
that
proposition.
would tantamount to violating the Constitution. Article 37,
What is your remedy?
37 says,
What is your remedy?
my lord, Article
None.
37 says that there
We
should
know
be
what article
inexpensive
says.
and expeditious justice.
So
So
what
if
is your remedy?
that is
Nothing.
tantamount to breaching the oath.
Yes, what is your remedy? File a reference against me.
So my lord, if
Then what will you do? Tell me.
I'll file early hearing applications.
Oh, I'm dismissed. That I dismiss.
And if it at
And then I
all,
dismiss, then what will you
if
do?
at all it was expedient, the Constitution should have been amended. Article 55A, for instance, should have been inserted.
Okay, ठीक है.
Titled Practice and Procedure of the Supreme Court.
ठीक है, okay.
My final submission, my lord, as I said that your lordship referred to the supreme law, the Quran and Sunnah. Now, consultation is a good thing. Nothing has restrained the Chief Justice from consulting his colleagues, but this law doesn't have a single word regarding consultation. And another thing, I can proclaim with pride that those were the Muslims who introduced the office of the Chief Justice. Imam Abu Yusuf was the first Chief Justice of human history. and he was not the appellate court.
Why was he the first Chief Justice? Do you know the story? That you don't know.
I don't know the story.
Yes, because the person who was nominated did not want to become Chief Justice. ये भी बताएं ना फिर, और उनको कोड़े खाना पड़े कि वो बनना नहीं चाहते थे.
Yes.
मैं इस काबिल नहीं हूँ.
Yes.
उनसे कहा गया आप झूठ बोलते हैं कि आप झूठे को चीफ जस्टिस बनाएंगे.
Yes.
वैसे आप बात ना करें, मगर मुझे इस्लामी तारीख में ये बता दें कि अपील का हक नहीं है. कोई ऐसा कानून है या शरई असूल है कि अपील का हक एक दफ़ा काजी ने फैसला कर दिया आखिर है कि अपील का कोई हक नहीं है. ऑफिस ऑफ चीफ जस्टिस बनने का मकसद ये होगा कि अपील का हक है.
He was the administrative head.
भाई अपील के हक की बात कर रहा हूँ, अपील के हक की बात कर रहा हूँ.
अपील के हक में my lord प्रो एंड कॉन्ट्रा आ रहा है.
प्रो बता दें मुझे, एक कौन बता दें.
अल इज्तिहाद ला यनक़दु बिइज्तिहादिन आखिर. Once an analogy is made that cannot be set aside by another analogy. So वो है,
बात अलग है, वो लोअर और ऊपर फॉर्म की बात होती है ना. उसमें भी इस्लामिक jurisprudence, इस्लामिक शरिया में there were tiers of courts.
But the Qazi al-Qudrat, he was the administrative head of the whole judiciary of the time.
जी आप कोई रेफरेंस कहेंगे? बस आपने कह दी.
That is without any
किताब का हवाला देना फरमाएंगे या नहीं?
डॉक्टर गाजी साहब अदब
भाई आप कोई किताब देना हवाला देंगे या बस ऐसे ही कह दिया?
डॉक्टर महमूद अहमद खाजी साहब की किताब है,
हमें किताब दिखाइए.
अदबुल काजी
दीजिए.
मैं दूंगा मालूम.
कब देंगे?
मैं जनाब को दिस इज
एकेडमिक
क्वेश्चन.
नहीं, ये एकेडमिक अमेरिका के लिए तो एकेडमिक नहीं है, न्यू जर्सी के केसेस को. मगर हम अपनी बारी इस्लाम की बात करते हैं तो फिर एकेडमिक हो जाता है.
एकेडमिक नहीं, मैंने तो
बताते ही नहीं. फिर आप रेफरेंस दें ना, फिर हम लिखें, नोट करेंगे ना.
अदबुल काजी महमूद अहमद, डॉक्टर महमूद अहमद गाजी माय लॉर्ड. सो विद दिस सबमिशंस इन नटशेल.
चलें, थैंक यू.
आई एम ग्रेटफुल सर.
कोई रह गया इस तरफ? और आपको सुना नहीं था पहले?
नहीं, बिल्कुल नहीं.
आप वकील हैं या खुद हैं पिटिशनर?
इन पर्सन.
जी
इन पर्सन. जी.
आपकी पिटिशन का टाइटल क्या है?
योर कॉन्स्टिट्यूशन पिटिशन नंबर 18, मोहम्मद शाहिद राना एडवोकेट,